There is a particular kind of silence that falls over a courtroom when something has just happened, that nobody in the room was prepared for. Not the silence of emptiness, but the silence of a collective breath held, of a room full of people recalibrating simultaneously, every person present suddenly, uncertain whether what they just witnessed actually happened, the way it appeared to. It was that particular silence that settled over courtroom 4 of the Harwick County Superior Court on a Thursday morning in March, following a moment that the bailiff would describe to his wife that evening as the strangest thing he had witnessed in 19 years of standing in that room. A 4-star admiral of the United States Navy had just saluted a woman in prison scrubs. He had done it slowly, deliberately, with the full formal precision of a military salute rendered at full attention, his hand rising to his temple while the courtroom watched, and the judge, whose gavel had been coming down to restore order, stopped mid-motion and stared. The woman had not flinched. She had simply stood straighter, already straight, but somehow straighter, and looked at the admiral with eyes that held something between, recognition and a grief so old it had long since been folded into the ordinary architecture of her face. Her name was Sarah Carver. She was 38 years old, and she was standing at the defendant's table in the navy blue scrubs of the county detention center, her arms bare, the burn scarring that covered her left arm from wrist to shoulder fully visible for the first time in a proceeding that had, until 30 seconds ago, been going very badly for her. The charge was aggravated assault. The incident had occurred 11 weeks earlier in the parking lot of a gas station on Route 12, where Sarah had, according to the prosecution's account, attacked a man without provocation, leaving him with 2 broken ribs, a dislocated shoulder, and a fractured jaw. The prosecution's account was not entirely wrong about what had happened. It was entirely wrong about why. The man, a person with a significant criminal history that had not been entered into evidence, whose counsel had successfully argued it was irrelevant to the immediate facts of the incident, had approached. A woman in the parking lot who was having difficulty with her car, and the interaction had turned, in the particular rapid way of certain situations that people trained to recognize them can identify in the first 3 seconds, dangerous. Sarah had been at the gas station. Sarah had recognized the 3 seconds. Sarah had acted as she had been trained to act, in exactly the way her training demanded, with precision, economy, and a level of effectiveness that had left one man requiring emergency care and one woman standing, confused but unharmed, beside her car. The woman Sarah had protected had given a statement to police. The police had arrested Sarah. Sarah's attorney, a court-appointed public defender named Gregory Marsh, who was thorough and overworked in equal measure, had spent the past 6 weeks trying to build a self-defense case around an incident whose facts were not in serious dispute, but whose framing was everything. The difficulty was not the facts. The difficulty was Sarah herself, who had declined, with a consistency that Gregory found both admirable and strategically maddening, to provide any context about her background or training that might help a jury understand why she was capable of doing what she had done in the time in which she had done it. "I need to know who you are," Gregory had told her in their 3rd meeting. "The jury needs to understand how a woman of your size was able to do that kind of damage to a man nearly twice her. Wait in under 10 seconds. Right now, the prosecution is going to argue you're dangerous. I need to argue you're trained. But trained how and by whom?" Sarah had looked at him. "I'll handle that part," she had said. Gregory had spent 6 weeks not quite believing her. The admiral's name was Thomas Whitfield. He was 61 years old, currently serving as Deputy Chief of Naval Operations, and he had driven himself to Harwick County Superior Court that morning, alone, without aide or driver in a personal vehicle, because he had received a phone call 3 days earlier from Gregory Marsh, who had found his name in the one piece of documentation Sarah had finally agreed, reluctantly, to release. He had not hesitated. He had simply looked at his calendar, cleared the morning, and driven. He was sitting in the gallery when Sarah was brought in, and she had seen him immediately. He had watched her eyes find him, with the particular, rapid scan of someone who has spent years in environments where knowing who was in a room could determine the outcome of the next 60 seconds. She had not reacted visibly. She had simply looked at him for one moment and then looked forward. He had expected nothing less. The incident that had precipitated the judge's outburst had been, on its surface, a minor procedural irritation. Sarah had arrived in the courtroom still wearing the green military jacket. Worn. Field issue. The word "for" stenciled on the breast. Pocket in the particular faded way of gear that has been used rather than displayed, that Gregory had arranged to have, brought to her from her belongings, for the hearing. The jacket covered her left arm. The judge, the Honorable Douglas Priest, 64 years old, appointed to the bench 18 years earlier, a man with the particular weary authority of someone who had seen a great deal and believed he had seen everything, had looked at the jacket with the expression of a man who had a dress code expectation for his courtroom and was about to enforce it. "Ms. Carver," he had said, "remove the jacket. This is a court of law, not a gymnasium." Sarah had not moved. "Ms. Carver," he had said again, his voice carrying the practiced edge of authority that expected to be obeyed. "Take that off." "Your Honor," Gregory had started. "Counselor, Your Honor, my client has significant scarring on her left arm that she has a reasonable preference not to display." "This court doesn't accommodate preferences," Judge Priest had said. "Bailiff!" It was at this point that Thomas Whitfield had stood up in the gallery. He had not spoken. He had simply stood in his full-dress uniform, 4 gold stars on each shoulder, the accumulated decorations of 40 years of service, arranged across his chest in the particular ordered precision of a military career that had run long and cost considerably, and he had rendered a full formal salute toward the defendant's table, toward Sarah. The room had gone quiet. Judge Priest had stopped mid-sentence. The bailiff had looked at the Admiral, looked at Sarah, and looked at the judge with an expression that suggested he was no longer entirely certain what the relevant procedure was. "Admiral," the judge said carefully, "I'm not sure what Your Honor," Thomas Whitfield said, his voice carrying the particular level, unhurried authority of someone who has commanded in situations considerably more demanding than a county superior court. "I would like, with the court's permission, to introduce myself and offer a brief statement relevant to the proceedings." Judge Priest, to his credit, granted permission. It was possible that some part of him understood, from the uniform and the stars, and the particular quality of the silence that had followed the salute, that he was now navigating a situation more complex than the one he had believed himself to be managing 30 seconds earlier. Thomas Whitfield walked to the front of the courtroom and presented, without notes, a statement that lasted 8 minutes and covered the following: the existence of a classified special operations unit in which Sarah Carver had served for 9 years, her rank upon departure from service, the nature of the training that rank implied, a description, carefully calibrated to remain within the boundaries of what could be discussed publicly, of the operational context in which that training had been applied, the incident that had produced the scarring on her left arm, which had occurred during a rescue operation in a location he could not name, in circumstances that had resulted in the extraction of 4 personnel who would not otherwise have come home, and the commendations, awards, and formal recognition that Sarah Carver had received in the course of a service record that he described, simply and without embellishment, as among the most distinguished he had encountered in 4 decades of service. He concluded by saying, "The call sign she carried for 9 years was Ironside. I used it when I saluted her because she earned it in conditions that this room is not cleared to hear. I saluted her because she is owed it. And I am here because she has apparently not told anyone in this proceeding anything I've just told you, which is entirely consistent with everything I know about her character, and entirely unhelpful to her legal situation. So I decided to come and tell it myself." He sat back down. The courtroom remained quiet for a moment that lasted slightly longer than most silences. Judge Priest set down his gavel. He looked at Sarah Carver, who was standing at the defendant's table with the same straight, patient stillness she had maintained throughout, the green jacket still on, her expression neither vindicated nor triumphant, simply present, the way she was always simply present. "Ms. Carver," the judge said, and his voice had changed in a way that was not dramatic, but was real. The change of a man who has just had his understanding of a room significantly revised. You may keep the jacket. The case did not go to trial. The prosecution, following a recess during which Gregory Marsh and the assistant district attorney had a conversation of approximately 45 minutes, moved to dismiss the charges, citing insufficient basis for prosecution in light of newly presented evidence regarding the defendant's specialized training and the documented threat context of the incident. The woman Sarah had protected in the parking lot, who had been present in the gallery for the hearing, wept quietly when the dismissal was announced. The man Sarah had injured was not present. His attorney had been in the room. Sarah walked out of courtroom 4 at 11:43 on a Thursday morning, having been in custody for 11 weeks, wearing the green jacket and carrying nothing else because she had arrived with nothing else. Thomas Whitfield was waiting in the corridor. They looked at each other for a moment. "You didn't have to do that," she said. "I was aware of that," he said. "How did you even know?" "Your attorney found my name in the file you gave him," he said. He called and explained what was happening. "I drove." She was quiet for a moment. "I know you didn't want anyone to know," he said. "You never did. That was always your prerogative, and I always respected it. But you were sitting in a county jail for 11 weeks for protecting a woman in a parking lot. And your record was sitting in a sealed file being extremely respectful of your privacy, and I decided those two things couldn't coexist anymore." She looked at the corridor floor for a moment. "The scarring," she said. "I know," he said. "I know what it cost you. I was there for part of it. Not enough of it." "You sent people," she said. "You got us out." "Not fast enough." "Fast enough," she said. It was not an argument. It was simply a fact she was placing in front of him. He nodded once, receiving it. She had a son. His name was Eli, and he was 7 years old. And he had been staying with Sarah's sister during the 11 weeks. And he was waiting in the courthouse parking lot in his aunt's car. And when Sarah walked out of the building and he saw her through the windshield, he was out of the car before his aunt had fully processed what was happening, running across the parking lot in the way children run when they are running towards something they have been waiting a very long time for. Thomas Whitfield watched from the courthouse steps as Sarah Carver, who had served in conditions this room was not cleared to hear, knelt on the asphalt of the courthouse parking lot and held her son with both arms and said something into his hair that nobody else could hear. He had served for 40 years. He had seen many things. He thought this was among the most important of them. The woman from the parking lot, whose name was Patricia Holloway, 44 years old, an elementary school teacher from the east side of town, wrote Sarah a letter, which was delivered through Gregory Marsh, which said, among other things, that she had attended the hearing because she had wanted Sarah to know she had tried to tell the police what actually happened and had been frustrated by the way it had been received, and that she was sorry it had taken so long, and that she had a daughter who was 8 years old, and that what Sarah had done in a parking lot on a Tuesday afternoon in December was something she thought about every day. Sarah wrote back. It was a short letter. It said simply, "You don't owe me anything. I saw what was happening and I did what needed doing. I'm glad you're all right. I'm glad your daughter has you." Patricia kept the letter for the rest of her life. Eli grew up knowing that his mother was someone who had done hard things in hard places, though the specifics came gradually, in pieces appropriate to his age and understanding, over the years that followed. What he knew first, and what he kept longest, was the thing she told him that afternoon in the parking lot, kneeling on the asphalt with her arms around him. She had said, "I'm here. Everything is okay. I'm here." He had said, "I know, Mom, I always knew you'd come back." And perhaps that is the quiet truth tucked inside a Thursday morning like this one, that the people who have given the most are often the ones most reluctant to say so, and that real honor does not require an audience, and real courage does not demand recognition, but sometimes a door needs to be opened for someone who has quietly accepted a room they should never have been placed in. And the opening of that door is itself an act of decency that costs something, the willingness to stand up in a quiet room and say plainly what someone else has earned and has never claimed. Sometimes the most important salute is the one offered not to rank, but to sacrifice recognized at last by the one person in the room who knows exactly what it cost